Will Forster.
Thank you, Madam Deputy Speaker, for calling me to speak on this important children's wellbeing and schools bill. I wish to focus my attention on two amendments, two new clauses. Firstly, new clause 33, that I'm calling Zara's Law, after Sara Sharif, my murdered constituent. And this comes out of the findings of a recent review conducted by the Children's Commissioner. I'd like to thank the NSPCC and others who have suggested a raft of great changes that could be made to the bill when it comes to improving how we look after children in the UK. And the list can be ever-ending, with so many great contributions from many. But knowing what happened to Zara, we know the system, I know the system, isn't protecting vulnerable children like it should. It failed her. So I'm hoping to untie that fundamental knot in the children's social care system. The sad reality is the level of support a child receives too often depends not on their needs, but on where they live and the thresholds that council has for stepping in and saving a child from abuse and neglect. As it stands today, there is an unacceptable inequality in how local authorities interpret thresholds for an intervention under Section 17 of the Children Act 1989. That means children at risk in one council area may receive early help and intervention if a family is in crisis. Yet in another, they're left without that intervention that could protect them, if not save their life. Every child in this country has effectively been entered into a postcode lottery, and we are gambling with their lives by not attempting to repair that flaw. We need to look at the devastating case of Zara to understand the consequences of having a system that lacks consistency and clear national standards. I don't think we can put a price on a child's life and only decide to step in based on resources, and that's the current system. It's clear that social services over the years have struggled, with deep cuts to funding and services, and the Liberal Democrats and I are not yet fully confident that the new government will fully fund local authorities. Zara was just 10 years old when she was brutally murdered after, sadly, years of torture and slavery at the hands that were supposed to love her. She was known to social services, yet the response was not sufficient to protect her. Would clearer national guidance with stronger thresholds for intervention have made a difference? In my opinion, yes. Would automatic referrals, such as those proposed in this clause, have ensured that professionals had the opportunity to intervene before it was too late? In my view, yes. The clause calls for a review of the variation in children in need support across the country and critically requires the government to establish national standards for when and how children should receive help. It sets out clear triggers for automatic referral to children's social care, such as when a primary caregiver enters custody or becomes an inpatient for mental health care, or when a child is arrested. There are moments of profound instability in a child in that case, yet without that clear national standards, without having a proactive approach, too many slip through the cracks. My constituent Zara slipped through the cracks. That is why in January, when I asked the Prime Minister if he would call for an inquiry into the failings of the state surrounding the death of Zara, he did say the government would look into it. We're still waiting for the Prime Minister to update the House. The proposed changes would set expectations on how frequently a child's situation should be reviewed. Cases like Zara's remind us that it's not enough to assess a child once and then step away. Their needs need to be updated and reviewed regularly. The risks can escalate quickly. There are warning signs, and if regular checks are not in place, intervention comes too late with morbid consequences. This new clause is about accountability, consistency, and most importantly, protection. We cannot continue to accept a system where a child's safety depends on geography and resource rather than need. I think MPs from across the House, but particularly the government, have a moral duty to protect these vulnerable children. And there are so many children out there that are still in danger. I hope NC 33 is agreed, and if it is not agreed, I hope the government would consider it, and particularly when it comes to the debate in the other place. Madam Deputy Speaker, I also wish to draw the House's attention to the Honourable Member for Lowestoft's amendment, NC8, that I know has been referred to today. That would ensure that corporal punishment could not be used as a defence in court if they're trying to hide from harming a grievous harm on a child. And I don't think this is about preventing parents from reasonably reprimanding their children. It's about closing a legal loophole that abusers have regularly used or attempted to use to evade justice. We saw this in the case of Zara, whose father, Irfan, sought to use such a defence to avoid accountability for the terrible suffering, tantamount to torture, is what the judge said, that Irfan inflicted. No child should endure such brutality. No perpetrator should be able to hide behind those awful, outdated legal justifications. I think we should standardise child protection in this country and close those loopholes that currently exist that abusers can exploit. This bill, if amended right, gives us that chance to do that. Let's take that opportunity and protect vulnerable children. Thank you, Madam.
Very powerful indeed.